And I guess, Darcy, if you could take the roll for us, please.
Sure, I'm promoting Murph to panelist here.
Yeah. There he is. Or at least his name popped up.
Okay. Commissioner Wilson,
Present.
Commissioner Satter,
Present. Sorry.
Commissioner Founds,
Here.
Commissioner Lee,
Present.
Commissioner Murphy,
Present.
Commissioner Lopes,
Here.
Commissioner Peterson,
Present.
Commissioner Cantonwine,
I think he was going to be late.
and Commissioner Stevens is absent.
Okay. So at this point in the meeting is an opportunity for members of the public to address the commission with any areas of issues of concern, except for the item that is on the agenda tonight. We will, if you want to speak about that, there will be an opportunity during the public hearing. So is there anyone in the audience that would like to address the commission? Apparently not. So let me turn off my other device here. Okay. All right then. I guess we'll get started with the public hearing. Let me get my script. Okay. So the public hearing is now open for the consideration of file numbers ZO315-25-CP and ZO316-25-ZAP, an application by Michael and Mary Padden for a comprehensive plan amendment to change the land use designation for the subject property from agricultural to rural, and corresponding zone change from exclusive farm use to rural residential farm use, 5 acres. The proposal includes an exception to statewide planning goal 3. This change is intended to facilitate the development of up to 3 dwellings. No development is proposed within this application. Assisting us in the hearing today are several members of the county staff, Principal Planner Martha Fritzy, Planning Director Jennifer Hughes, and Administrative Specialist Darcy Reinhardt. This public hearing is being conducted virtually using the Zoom platform. Panelists for today's hearing will include members of the Planning Commission and county staff, have both and video capability. The applicant will be added as a panelist during their presentation. If a panelist is participating with audio but not video, members of the audience will not see the panelists' names on their screen, but will be able to hear them when they speak. Audience members who have joined the meeting will have their mics muted unless they wish to testify, in which case they will be called upon to do so by the county staff moderator. Audience members' video will not be turned on at any time. Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website as soon as possible. So I have a few general statements before we get started. The Planning Commission is charged with making a recommendation on the application to the Board of County Commissioners. The record from this hearing will be forwarded to the board, which will make the final decision on this matter. The board will conduct another hearing on this application in person on Tuesday, February 10th, 2026 at 11 a.m. That hearing will be de novo, meaning that the hearing will be started anew and additional testimony may be offered. Tonight's hearing may not go beyond 10 p.m. unless a majority of the planning commissioners in attendance vote to continue past that time. If not concluded, it will be continued to a date and time certain. The hearing may be continued for other reasons as well. If an announcement of an additional hearing date and time is made tonight, it will be the only notice given of that additional hearing. So now I'm going to talk about how we're going to conduct the hearing. So it'll be conducted as follows. First, we'll see the staff report from the Planning and Zoning Division. Then any entry into the record of any additional correspondence that we received, any technical information from other government agencies. Then there will be testimony by the applicant or representative, the maximum length 20 minutes. Testimony of representatives of recognized community planning organizations or hamlets, maximum length 10 minutes per CPO or hamlet. Testimony by proponents of the application, maximum length 3 minutes per speaker or more if I so think it's needed. Likewise, testimony by opponents, maximum length 3 minutes. Testimony by persons who are neutral in the application, again, maximum 3 minutes. Then the applicant's rebuttal, which is limited to arguments addressing evidence already in the record, maximum length 10 minutes. Then there'll be an opportunity for Planning and Zoning Division staff rebuttal, which is limited to addressing evidence already in the record. Then we'll close the public hearing, and then the Planning Commission will have a discussion and take any action. So, as I mentioned, there is a designated time during the hearing when it will be open for testimony. I will make it clear when this is. If you want to provide testimony, you will utilize the raise hand feature in Zoom. Attendees on a PC or iPad, you have a raise hand button on the Zoom bar, top or bottom, depending on your device. Attendees by telephone use the *9 to activate the raise hand feature. When moderator switches you over to provide testimony, your screen will look different for a moment. Primarily, you will see all the participants' cameras, not just the one who is speaking. Staff will call upon you when it is time for you to provide testimony. For the record, please begin by stating your name and where you are from and whom you are representing. If you would like a copy of the final Board of County Commissioners decision on this matter, please provide your mailing address. Once you have provided your testimony, your mic will be muted and your screen will be returned to normal. Now is the time for the public hearing related to previously identified comprehensive amendment and zone change applications. This is a quasi-judicial land use hearing, which means two important things for those participating in this hearing. First of all of the criteria that the Planning Commission can use in reaching a recommendation are listed in the notice given for this public hearing and will be identified when the oral staff report is presented. All testimony, arguments, and evidence must be directed towards these criteria or other criteria in the Comprehensive Plan, Zoning, and Development Ordinance or other land use regulations that the person testifying believes to apply to the decision. Accordingly, anyone testifying is asked to please direct your testimony to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue may preclude appeal to the Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow that the county to respond to the issues precludes an action for damages in circuit court. Once final, the county's decision may be appealed to the Land Use Board of Appeals. At this time, I'm going to ask members of the Planning Commission to disclose any ex parte contacts, bias, or conflicts of interest. Please indicate the nature and extent of the ex parte contact, bias, or conflict of interest, and indicate whether you intend to participate in or abstain the hearing. If anyone wishes to challenge the impartiality of any commissioner, please clearly indicate your intention to do so in a written or oral testimony you may provide. I see Commissioner Lee has their hand up.
Yes. Thank you, Chair Tom Peterson. I have two things to disclose. The first is, as I mentioned before, in the past, I've worked with the applicant's planner, Peter Finley Fry, on several projects, the most recent one being over 10 years ago. I have not discussed this case with Peter. Number two, one of my current clients is in the middle of settling a contractor bankruptcy case, and my client has engaged two attorneys that work for Dunn Carney, which is the same firm as the applicant's attorney. Even though I've been working with different attorneys, it is the same firm, and I have been to their office for a client strategy meeting a few months ago. In addition, I was asked, and I've submitted my professional resume to Dunn Carney for consideration in future cases as an expert witness. I have not discussed this case with any attorney at Dunn Carney. Even so, in order to not have any appearance of ex parte contact, bias, or conflict of interest now or in the future, I will be abstaining from voting on this application. Thank you.
Thank you for sharing that. We still will appreciate your thoughts and opinions, though.
Will do.
Okay. Okay. Now it's time for the staff report. So, Martha, I guess I'm turning it over to you.
Thank you. And good evening, everybody. I have a presentation to share that is a little lengthy, but this is a complicated topic, and I'm hoping that we can get through it. And so, are you seeing the entire presentation, or are you seeing it in like presentation
The whole
format?
screen, including the slide deck
Oh.
on the left.
Excellent. Not really. There, how's that?
There you go.
Okay, so alrighty. So as Chair Peterson mentioned, we are here to discuss a proposed comprehensive plan map amendment and zone change. File numbers Z015-25 and Z315-25 and Z0316-25. So the proposal, as was read by Chair Peterson and as was discussed in your staff report, includes the following: a proposed plan amendment and corresponding zone change. The plan designations would change from agriculture to rural, and zoning from EFU, exclusive farm use, to rural residential farm forest 5 acre. Such a change would require exceptions to two statewide planning goals: Goal 3 agriculture and Goal 14 urbanization. The purpose was to facilitate development up to 3 dwellings, and importantly, nothing that we're doing today would authorize any specific development. So as of this morning, we've received an amended proposal, and that amended proposal changes one thing. The request is for farm forest 10 acre and FF10 zoning rather than the RRFF5. And on the face of things, this seems pretty substantial, but as a practical matter, it is not. And I will attempt to explain why. For one, you'll notice here the plan designation to and from is not changing. And so the proposal would still request a plan designation, a plan change from agriculture to rural. That still requires an exception to statewide planning goal 3. What the difference is that in our comprehensive plan, under the rural plan designation, we have 3 different zoning designations that you could potentially apply: a 2 acre, a 5 acre, and a 10 acre. And originally they had asked for the 5 acre zoning district. They are now asking for the 10 acre zoning district. And the effect of that is it eliminates the need for the Goal 14 exception. And I'll explain a little bit more about that later on in the presentation. Substantively, and in terms of the criteria that need to be addressed, there's really only one section in our comprehensive plan that would differ between a farm forest, an FF10, and an RFF5 designation. And so we'll talk a little bit about that as well. All of the rest of the criteria under the goal exception to goal 3, under the rural designation, all of those remain the same under this new proposal. Also notably different is that if it were approved, it would facilitate development of only one dwelling, not 3. Again, we're not actually authorizing any development with this. So, oh, that's really out of focus. So the subject site, it is roughly rectangular. It's on the south side of Southeast Algiers. I'm not sure if I'm saying that correctly. Just under 15 acres. The site itself is relatively flat. It has no overlays in terms of resources like streams or wetlands or steep slopes, floodplain, anything like that. It is currently developed with a 24-foot by 30-foot agricultural building. This building was approved through a 2024 permit for to support agricultural use on the property, presumably. When you get approved for an agriculture building, often called an ag exempt building, you need to demonstrate that it is supporting some agricultural use on the property. In this case, that was done through the demonstration that the property is in special assessment or farm tax deferral. The uses surrounding the property are fairly mixed. As you can see, there's some treed areas immediately adjacent to the site are some small to medium-sized farm properties, a lot of which do contain dwellings. Adjacent to the southeast corner of the site is an exception area, a rural residential area with smaller lots. Those are most, if not all, in this immediate area also developed with a dwelling. This shows the zoning, and the subject site you can see is surrounded on 4 sides really by EFU zoning. In that lighter green, in that general area, lots generally range from about 3 to 29 acres. They are not extraordinarily large farm parcels, but they are farm zone parcels, and many do engage in farming. Again, to the southeast and further east in that sort of beigey color is the exception land that's referred to frequently in this application. It's zone RRFF5. Lots in this area are a lot smaller. They generally range from about 1 to 6 acres. I think they average somewhere between 3 and 4. Farther to the west and south, the other green colors are timber zoned and ag forest zone properties. It just shows that there's a lot of resource zone properties around here. They are not all farm. There definitely is a mix of farm and treed areas in the vicinity. So the site itself was zoned for farm use in 1980. It was part of the Furwood Bull Run zoning amendment, a comprehensive plan amendment that established the current zoning scheme in this area. The subject site itself was located in a little over 2,000 acre area identified as A7 or west of Furwood. You can see within that area, there are a lot of farm properties that are smaller in size. Nearly half are 10 acres or smaller. Only just under 24% are actually over 20 acres in size, and the average parcel size is just over 14 acres, very similar to the subject. That nearby exception area, sort of to the south and east, was called Moorfield Meadows in the findings related to those plan amendments. It's about 270 acres, very small lots. By far the majority are 5 acres or less. There are a few larger, none are over 15 acres. The average parcel size there at the time was about 3.38. And I bring this up for a number of reasons. One is that when you look at the parcelization around the area now, it is largely the same. And not a lot has changed in this area in terms of parcelization since this zoning scheme was established in 1980. What has changed, presumably, is the map soils on the subject property itself. And so when it was originally designated as agricultural land, it was identified to contain all Class 2 soils, this the number 15 or symbol 15B listed up here. The applicant has engaged a soil scientist to dig some test holes and do an analysis of the actual soils on the property. That soil scientist found that actually just under 50% of the soils are that Class 2 high value, that 22.5% are actually a Class 4 soil, and then nearly 30% is a Class 6 low value soil. And this holds some relevance to the goal exception that we're going to talk about at hand, but in and of itself, just because the soils are different than what was originally mapped, certainly doesn't justify a goal exception. And in fact, both state law and the county's comprehensive plan identify agricultural land as primarily classes 1 through 4. So high value or low value, it appears that the classification as agricultural land, at least under those definitions, would still hold here because well over 50% of the parcel is in Class 1 through 4 soils. So moving along, notice of this application was sent out as per state and county requirements. It was sent on December 18th last year. We have received 3 comments to date, one from 1,000 Friends of Oregon, one from DLCD, Department of Land Conservation and Development. Both of those are state agencies, or I guess 1,000 Friends is not a state agency, but they deal in statewide land use issues. Both, as you've probably noted, have recommended denial of this proposal because both argue that this proposal does not meet the standard for the goal exception that they're requesting. The 3rd comment was from county's engineering staff, who always reviews traffic studies that are required anytime we do a comp plan zone change. In this case, I'm not really going to talk much about the traffic study. I'm happy to answer questions if you have questions. Traffic was not a concern, either for the traffic engineers or for county engineering staff. And so engineering concurred with the findings of the traffic study that both the safety and adequacy of the transportation system can be met with this proposal. Excuse me. And then finally, this morning, the applicant provided some supplemental information, including findings and this revised request to go to the FF10 zoning designation rather than the RRFF5. That's Exhibit 6. I did send that. I had asked Darcy to email that to you this morning so you'd have a chance to take a look at it. The local community planning organization is Furwood Neighbors. They have not provided any comments. So we're going to move on to the meat of this finally. I did want to provide you that spend a few minutes providing that context so we all were sort of starting from the same place. So per usual, a comp plan zone change involves a number of different criteria and policies that need to be met, including in this case, statewide planning goals and associated Oregon revised statutes and Oregon administrative rules related to Goal 3 and Goal 14 and specifically to goal exceptions. And then county comprehensive plan goals and policies found in the chapters here. And then zoning and development ordinance criteria that are found in these various sections of the ZDO. All of these are discussed in detail in your staff report. And as I mentioned, most of them are still completely relevant with this new proposal. And so I'm not going to talk about a lot of them. The ones that are noted here, this application has met, and so I'm not really going to spend any time, but I'm happy to answer questions. Like I mentioned, the transportation, which is often a big topic in our zone changes, but it is not here. It bears noting that Section 202 under zone changes, there are 4 big criteria for zone changes. 3 of those 4 have been met by the criteria to relate to the adequacy and safety of the transportation system. 1 to whether or not services can be provided as needed. The one that is not met is the requirement that this proposal meet all of the county comprehensive plan goals and policies. You'll notice chapter 4 there is not checked off. So in the original staff report, I'm sure you're all aware that staff has recommended denial of these files for 4 reasons. One is that it does not meet the criteria for an exception to statewide planning goal. 3, it does not meet the criteria for exception to statewide planning goal 14. It is not consistent with all the county comprehensive plan policies for a rural plan designation. And it was found not consistent with all the county comprehensive plan policies for the RRFF 5 designation. I was originally going to talk through each of these in a lot of detail. I am still going to talk about each of these, but I will also, to the best of my ability, sort of add discussion about what has changed under this new proposal based on my read of the materials that was submitted this morning. And so for obvious reasons, number 4 is going to change. The first one is going to be long and a little complicated, and I apologize. It will not all be this long, I promise. So we're going to talk about goal exceptions first. What is a goal exception? So you all are most likely aware that the state has 19 statewide planning goals that all jurisdictions need to meet if relevant. Actually, 15 are relevant in Clackamas County because we don't have any coastal lands. The other ones are related to coastal lands. If for some reason there is a proposal that based on the site-specific and certain project-specific conditions there's a proposal that would not meet one of these statewide planning goals, there is an opportunity under state law to apply for a goal exception, not to every single statewide planning goal, but in this case, you certainly can apply for statewide planning goal 3, which is agriculture. State law identifies 3 types of exceptions that you could take potentially, and then also identifies criteria that need to be met in order to meet the standard for each of these. So these 3 exceptions are physically developed, where your property itself is physically developed to the point where the resource is no longer practicable. Clearly not the case here because the site's largely vacant, right? Irrevocably committed, in which the nature of nearby physical development makes a resource use on the property impracticable, or a reasons exception, which is honestly by far the hardest and the highest bar. You have to identify that there's a need specifically for the development that you're proposing on this site. It cannot reasonably locate elsewhere. It's compatible or can be made compatible with other adjacent uses. And so generally speaking, the bar is very high for all of these. This is state law, and state law was written intentionally for that purpose. So the bar is pretty high in order to take agriculture or other resource land out of resource designations. So in this case, the applicant has applied for an irrevocably committed exception under state law. It is identified as areas where the land subject to the exception is irrevocably committed to uses not allowed by the applicable goal because existing adjacent uses and other relevant factors make uses allowed by the applicable goal impracticable. And I added that emphasis. This is the lens with which we need to think about this irrevocably committed exception. So a couple things to think about as we are considering this. What does impracticable mean? There's no definition in state law. When you look it up, you get lots of broad definitions, near as I can tell. It basically means extremely difficult or impossible or excessively difficult. So the standard it is not that you have to show it can't be done, but that it is extraordinarily difficult. There has been case law that have also provided direction on what uses you need to address, like what uses you have to look at that are impracticable. And in this case, in all cases, you don't need to look at the entire litany of uses that may be allowed, like under conditional uses or things like that. You need to look at, for goal 3, you need to look at farm uses. And under ORS 215-203, farm uses have a pretty big definition. Generally includes employment of land for the primary purpose of obtaining profit and money by raising and harvesting and selling crops, feeding, breeding, management, sale of the or the produce of livestock, poultry, fur-bearing animals, stabling or training equines, and then it includes actually a fairly sizable list of other sort of related uses. This also becomes important. Farm use doesn't just mean cultivating the land and growing something. Farm use has a pretty broad, but understandably broad definition. And so then finally, for the primary purpose of obtaining profit, that phrase is discussed a little bit in the findings that were submitted today. It is not defined under state law, and the Land Use Board of Appeals actually in the past has rejected arguments that a county can establish some sort of level of profitability necessary to qualify as a farm use. In this case, case law has also identified that a determination whether farm uses are impracticable is really a matter of case by case. It has to be looked at in a case by case analysis after consideration of all the factors. It's not simply looking at whether or not the site can make a profit through farm use. So all of these things are important to understand what we are looking at in this irrevocably committed proposal. So also in Exhibit 6 in the findings that the applicant provided this morning, they made reference to some summary of a case from 2007, an assertion that it wasn't rebutted or addressed. And I think that part of the reason is that staff agrees because that is what the case found. In the case of an irrevocably committed exception, it must be evaluated in light of practical real-world conditions, not theoretical possibilities. In addition, it must identify conflicts caused by, and again, I've added the emphasis here, caused by nearby residential uses that render the resource uses on the subject impracticable. And technically it says caused by adjacent uses on adjacent properties. And it also requires you to look at the relationship between the site and the lands adjacent to it and identify land use conflicts that undermine the viability of the resource use. And so those are all very important points and points that are addressed in part by the applicant. But the applicant really relies on this list of reasons that they say render the resource of the site impracticable, including the proximity to existing exception area, talk about parcelization, some conversation about drift of sprayed pesticides and herbicides, which quite frankly to me was a little bit confusing because there was no evidence that there was any history of pesticide use on this property or on adjacent properties. And quite frankly, the impact is supposed to be how the adjacent properties would impact the subject site and therefore make it impracticable to farm or to have a farm use on. The unavailability of water, transportation system impacts, again, were a little bit confusing to me. They seem to rely on a general comment in the traffic study that says, well, generally traffic from agricultural uses, because it includes heavy equipment, may sometimes conflict or make less safe the roads than just general cars from a rural residential. It was nothing site specific. It was just sort of a general comment. And then this idea of profitability of farming the site and an assertion that because it's 15 acres, it cannot be farmed profitably. There was some discussion about it requires a dwelling to farm it and or security. And so while the additional findings that were submitted this morning did expound on some of these a little bit, staff really finds that the applicant relying simply on the subject size and these theoretical impacts to farming that the subject might have on nearby exception areas rather than the impacts that the adjacent properties have on the site itself were not particularly compelling. And the applicant, quite frankly, doesn't identify any conditions or development on nearby lands that have caused such a conflict that the subject cannot be practically farmed. And in fact, in the applicant's materials, when they were summarizing some of this case law, they noted, and staff agrees, that the mere presence of adjoining residential uses is not sufficient to conclude resource lands are irrevocably committed. And so there are nearby resource lands and resource uses on agricultural lands, but just because there are dwellings on those property, the LUBA and the state have found are not that simply those being there is not sufficient to conclude that the resource land is committed to something else. And then finally, although it is asserted by the applicants, no evidence has been provided to demonstrate why farming on 15 acres is impracticable simply because of its size. In fact, county evidence shows that parcels of 15 acres or even less can be farmed and can generate enough income to qualify for a dwelling. From 2022 to 2025, there have been 14 approved and 1 pending applications for a dwelling in conjunction with farm use. And of those 15, 4 of those parcels are 15 acres or smaller, 3 are high value and 1 is low value. And so it's pretty clear that generally speaking, as was asserted through some of this evidence, that a 15-acre parcel can be farmed and generate enough income to qualify for a dwelling. And there was no discussion in any of those applications about needing security in order to farm and generate enough income to qualify for that dwelling. And so honestly, for me, it comes sort of down to this idea. The irrevocably committed exception requires demonstration that adjacent uses have somehow committed the subject site itself to uses not allow or to so that it's impracticable to do what is allowed under the current zoning, under the resource zoning. And so this is a photo from 2018 where it's clear the subject property in yellow is in hay production, largely. And then on either side to the east and west, based on information provided in the application, those 2 properties are engaging in horse boarding. Well, boarding a horse is a presumably intending for profit farm use. It's a farm use listed under the state law, and horse boarding generally requires a fee. And so those 2 properties are clearly engaged in farm uses. The property to the south, if you look at the historical aerial photos, it looks like nursery stock on that property. It's sort of in different states and configurations over the course of the years, and that's clearly in farm use. And then one of the letters submitted by the applicant is a property to the north and identified that they have a family and they have a house and a cat and a dog, but they also have livestock on their property, which is a farm use as well. And so it's pretty clear from this aerial photo that at least in 2018, there was farming going on the property, and there continues to be farming adjacent to the property. The existing rural residential exception lands technically do abut this site. It touches the corner to the southeast, but there doesn't appear to be anything about the existing exception land being located there with a much bigger boundary on the horse boarding property or the nursery stock property that has made it impracticable for those properties to engage in farm uses. And there has been no explanation or evidence provided that something has changed, that there's something different between 2018 when the subject property was in farm production until now that would somehow, and I guess I use the word preclude and I don't mean preclude totally, but to make it impracticable to continue to farm this property. So in addition, the material that was provided today as exhibit and your exhibit 6, the applicant's revised findings really didn't address a number of the other identified deficiencies that were identified in the staff report related to the Goal 3 exception, including but possibly not limited to addressing Oregon Administrative Rule 660, Division 4, Section 18.2, which requires that new exception areas address how changing how this new or how in allowing this new exception area would not commit other adjacent land to non-resource uses and would be compatible with adjacent resource lands. And particularly in this context, when the applicant appears to be using the argument that the adjacent exception lands are committing this property. And so it's a little bit of a circular argument, and that is clearly not addressed. by the applicant. So as such, staff finds that the requirements for an irrevocably committed exception to goal 3 are still not met with the new information that was provided. I told you that was the longest one, I promise. So the second one is actually pretty easy. It has to do with the statewide planning, the exception to statewide planning goal 14. The administrative rule listed up here requires that new rural residential areas either have a minimum parcel size of at least 10 acres or justify an exception to statewide planning goal 14 and also maintain a minimal parcel size of 2 acres. The applicant did not request the goal 14 exception for the original RFF5 zone, smaller than 10 acres, so it would have required it. Because the new request is for the FF10, which is a 10-acre zoning district, that effectively eliminates the need for the goal 14 exception. I missed a word, for the goal 14 exception in this proposal. So this is no longer an issue. What does still need to be addressed, even with this new proposal, like I mentioned, are the rural plan designation policies, because regardless of whether or not this is FF10 or RFF5, the plan designation is rural. And so the applicant's findings, including the revised findings, didn't address all the criteria in this policy listed here, and didn't fully address the other relevant policies that were identified in the staff report. This policy I pulled out because it's pretty big, and it says that new exception areas shall provide findings demonstrating that, or shall provide findings that demonstrate these 4 things: reasons why it's needed, why alternative areas are not suitable, an evaluation of the easy consequences, and reasons why it would be compatible with other adjacent uses. I mean, technically it was addressed, but it was essentially addressed without any particular evidence. Not all of these 4 areas were addressed, and it was just effectively stated that the proposal meets these policies without providing the adequate evidence behind them. And so these are still not addressed adequately. However, there is really one plan policy with a number of sub-policies that relate to when you designate the FF10 versus the RFF5 zoning. The applicant's findings in the original application did not address all the relevant policies for the RFF5 designation. However, they no longer have to. And unlike those policies, the FF10 sub-policies are much broader and more permissive, and only one or more of those 3 listed there need to be met, whereas in the RFF5, all of them had to be met. And so the applicant's revised findings generally address these policies, and staff does find that they could be met for this parcel if we could get there with the goal exception, with meeting the rural policies. So, in conclusion, staff finds that goal 14 exception is no longer needed, that policies specific to the FF10 designation could be met. However, staff still recommends denial of these files for 2 reasons. One is that staff finds it does not meet the criteria for an irrevocably committed exception to statewide planning goal 3, and that it is not consistent with all county comprehensive plan policies for the rural plan designation. That is it. How do I get out of here?
Okay, are there any questions for Martha? I'm looking for a raised hand. I don't see any. I have one question. Could you explain this issue of the dwelling qualifications requirement? Help me understand what that is, what that means, because it certainly was brought out in their testimony or their submission. So I'm not familiar with that. Could you educate me on how that works?
So are you asking about my comments that there were 15 other parcels that qualified for a
No,
dwelling as
that-
farmland?
No, it's this whole issue of it has to qualify to allow a dwelling.
Oh, okay.
What does that mean?
So under the current zoning, which is exclusive farm use, dwellings are not an outright allowed use. So in other words, you can't just come in and submit a building permit and be allowed to build a dwelling. There are certain ways in the EFU zone to get a dwelling approved. And the most common way for vacant property is to farm the property, generate a certain amount of income for 2 years or 3 of the previous 5. And then if you are farming and generate that income, then you would be allowed to build a house. It's called a dwelling in conjunction with farm use. There are a few other ways, but that is by far the most common. And so, did that answer your question?
Yes, it does.
Okay.
And
I'll
just
stop
out of
there.
curiosity, so prior to 1980, were there any criteria that restricted someone from putting a dwelling on a property like this? Do you know?
I don't believe so. I believe, I could be wrong, but I believe this area was unzoned prior to that. That was the first restrictive zoning that restricted it to farm land with these other potential options to get a dwelling on it.
Okay, so essentially the state land use laws enacted in 1980 then made this new requirement for the ability to put a dwelling on a property of that size.
Yeah, yes, and quite frankly, under the farm zones, the rules for how you get a dwelling have changed over the years.
Okay,
I mean, but this sort of the basic concept of dwellings are not an outright allowed use, you have to do something,
gotcha.
was certainly established in 1980.
Okay. Not like the old days of farmers, first thing they did is put up a cabin. Anyway, Commissioner Wilson, you have a question.
So Martha, from what I just heard you said, in order to put a piece of a property, a building or something on this property, they have to farm it for 2 or 3 years and show a profit, and then they can put a building or home or something on it. It looks to me like somebody was using that to harvest hay. Now, maybe it was the same people, maybe it wasn't. If they've generated profit off of it with farm use, would that qualify?
So the standard is for the previous 2 or 3 of the previous 5. The aerial photo that shows the hay is actually from 2018. I mean, so that time period would not qualify. And I don't know who was farming it then. The current owners bought the property in 2023, I believe, give or take a few months. And so it would need to be farmed now and generate that income. Alternatively, I mean, there are other ways, they're just not as common and they're harder. There is what's called a non-farm dwelling. If you can demonstrate that you have poor soils, there's a lot of analysis and I don't know if it would qualify for that or not, but there are a few other ways to get dwellings on a property.
Okay. I saw on the picture there looked like on the older picture that was on there, it looked like there was some forest land on one part of that, and that's gone now. Do you know what happened there?
No, there were trees and they're not there anymore. So I don't know.
Okay, thank you.
Commissioner Murphy.
Thank you, Tom. Martha, I have a couple questions. In the Furwood Bull Run zoning, has this been done before? Has there been a zone change from EFU to FF10?
Oh gosh. I don't know. I can tell you that it's very, very difficult to change from farm to a rural residential zone. There have been very few done. I'm aware of only a couple in the county that have happened, none in this area. And since I've been doing zone changes for about 10 years, I've not done any in this area that I'm aware of.
Okay.
Certainly not from farm to rural residential.
Is it common practice for the county to judge how much money somebody is going to make off a particular soil? I mean, isn't that more of a business practice than if you're looking at soil that you think you can't make? It kind of depends on the businessman, doesn't it, to how much they can make or what product they decide to grow, or I could think of many different reasons other than it's the soil's fault for not having a profit.
Absolutely. And we are not making a determination how much money they can make specifically based on soils. The idea of making a profit in order to qualify for a dwelling is actually a construct under state law. It's a way, and it doesn't say how. It has to be done through farm uses. It can be livestock. It can be equine facility. It can be crops in the ground. It can be nursery stock. It can be anything that's listed as a farm use. The dollar amount is established under state law based on high value or high value or low value farm soils.
Okay. And another point that keeps being stuck in front of me here is the pesticide and herbicide drift. Now, is there a liability if Clackamas County decides that it's okay to have a residence in an area that is subject to pesticide and herbicide drift? I mean, if it's being acknowledged that there's a problem there, aren't we putting people in harm's way by saying, well, can't farm there, but by golly, we can put residents there with kids and dogs and whatever. To me, it seems like that's not an argument. It's pretty far-fetched, actually.
So to answer your liability question, I don't know. Jennifer may have to help me out here. I know that there is a right to farm in this state, and there are certain protections for farmers. I don't know a whole lot about it, and I'm not an attorney. I don't know how far, how and where that extends. I don't know that based on the information given in this application that there's actually a problem identified or any evidence that this is actually happening here. It seems more of a theoretical argument about this is a potential conflict that could happen.
Yes, that's how I kind of see it too. Thank you. Yeah, very well done presentation. Thank you.
Commissioner Founds, your hand's up.
Yes. I have a question about that egg building that you said they put an application in for last year. Would that have been allowed if this was zoned differently?
Potentially, yes. Ag buildings are allowed in a number of different rural zones, including rural residential zones where farming is also allowed. And so the standard is that you have to demonstrate that it's supporting some sort of farm or forest use.
And does that have to be demonstrated or for that permit to be approved?
Yes, you need to provide some evidence, although typically we would accept evidence that the property is in a farm or forest tax deferral status, because that implies that the tax assessor knows, or that there is something going on the property. I don't know what the specific standards are to be in farm deferral. So in this case, they did show that they were in farm deferral.
And that kind of shows that it's being used as a farm for, make some sort of money at this point or something, right?
Presumably. I don't think there is a requirement to make money to be in farm.
Okay,
tax
to
deferral,
use for that.
But it's a use, yes.
Okay, thank you.
Commissioner Lopes?
Yeah, I was going to ask about the farm tax deferral, but we don't know definitively if it was farmed or being farmed to get that tax deferral. It sounded like the submission of that document infers that someone has authorized or verified that it is being farmed to get the tax deferral. Am I interpreting that correctly?
And that would be between the property owner and the tax assessor, whatever their requirement is and whatever evidence they require to show. I frankly don't know what that is.
Okay, and I had one more question. In the staff report, it talked about a recent aerial photo of the property showing a recreational vehicle on the site that it appeared set up for occupancy, and then it said that it's not currently an allowed use of the exclusive farm use zone. Do we have any more information on that RV?
No, and it's not particularly relevant to any of the criteria here. It just shows up in the aerial photo, and I felt need to acknowledge it. So because I figured someone would ask about it. I don't even know if it's still there, to be honest.
So the recent aerial photo, recent could be like a few months ago, but not necessarily yesterday.
It was 2025. The Google Earth photos were summer of 2025. I don't know when these other ones were.
Okay, thank you.
Commissioner Wilson.
Yeah, follow-up question. They changing the designation that the applicant is applying for to forest use. Is that correct?
No.
What was
No.
FF?
So it's a little confusing because the name is Farm Forest 10. It's really a rural residential zoning district with a 10-acre minimum for new lots. All of our rural residential zones also allow farming and forestry uses on them. But for some reason, this one was just named Farm Forest and didn't have the rural residential plopped in there.
Okay, so if they go in and they plant some trees to raise Christmas trees or something like that, would that allow them to build a building on there?
So if they were to be successful in the rezoning to FF10, they wouldn't need to plant anything on the property. They could come in and apply for a building permit and build a dwelling. There's no
Thank you.
requirement to farm it. There's no requirement to generate income.
Okay.
Commissioner Satter.
Could you tell us more about the soil and how that affects the decision?
So that's a good question. The basis for an irrevocably committed exception is that development or uses on adjacent properties have somehow render it impracticable to farm this particular property. The fact that the map soils are different than what was originally thought is not particularly relevant, although I believe the applicant would disagree. Thousand Friends and DLCD both identified that whether or not these are high value or low value soils doesn't matter or is not a particular relevance for the irrevocably committed exception. And largely, not largely, but in addition, the fact that it is still mapped primarily with class 2 and 4 soils would mean that it would still continue to meet the definition of agricultural land, which is defined as primarily class 1 through 4 soils. So I don't know that that's really what you were looking for. It's just that it's not necessarily directly relevant to the irrevocably committed exception.
That was what I was looking for.
Okay.
Okay, I don't see any more hands raised, so I guess we will move on to the next part of the hearing. So have we received any additional correspondence on this matter, other than what we received today and what was in the packet?
No, we have not.
Okay. Are there any government agencies here to provide technical information related to this application? I don't see anybody on the listed, so I'm assuming no. So with that, it's the applicant's opportunity now to present their proposal. You've got 60 minutes if you need that much time. And I guess we can get started. So Darcy, will you bring the applicants on?
The applicant is already in.
Oh, okay.
There may be more than one applicant who's testifying today.
I have somebody
Peter
named
can let us know.
Rainier.
This is Peter Finley Fry. I'm actually not technically the applicant. Ty Wyman, our attorney, is the applicant, and the patents who own the property are the applicant. And I'm not exactly sure how I managed to get into your meeting like this. Well, they did not. And I've been quiet and, as you know, turned off. And thank you for letting me be in the meeting, but I'm not really. Ty Wyman is the one who's supposed to be presenting.
Is Rainier your applicant?
No, it's Patton and Ty Wyman is attorney with Dunn Carney.
There is a TKW in the attendees. I'm guessing that might.
That would be I'm sorry, and I
Okay.
will come back when it's time for me to come back, but I'm not here to present the beginning.
And Rainier has their hand raised. I'm wondering if that is the Pattons and somehow it's not identified as such.
I can give him a moment to speak.
Can you hear us?
Oh, there I am.
Hello? Can you hear us?
Yes.
Okay,
Yes.
sorry. We have two separate cameras set up in one room. So Rainier is going to be the Pattons, and then Ty Wyman should also be under TKW. And so I think you can see him now, you can see him now, and he's going to speak through the Rainier microphone, though, if that's okay. Does that make sense?
It may cause reverberation in the audio.
Well,
Okay.
that's why his audio on his computer is turned off. And so
Okay.
he's just speaking through Rainier for that reason, so that we don't have the reverberation.
Okay.
Yeah, so go ahead, Ty, you can speak now. So leave it on Rainier for talking, though. Don't mute Rainier.
Please,
Sorry.
please, please. Thank you so much, Mr. Chair. And when you said 60 minutes, I did see the expression on Ms. Hughes' face. I assure you, Jennifer, I can come in under 58. No, kidding aside, truly kidding aside, because the first thing I want to do is thank all of you, really. Commissioners, we understand that you are volunteers. We absolutely respect your service, and your staff. I can't tell by the gray hair here. I've practiced land use law in Portland 33 years. Clackamas County staff is absolutely at the top of professionalism, and that includes this case. We find ourselves, of course, in disagreement, and that's fine. I hope it's fine with you. We are going to state some disagreement with staff, but we do appreciate the way in which they have treated us through this. So who are we? I am joined by, and I'm not sure if you're going to be able to see them, but I am joined by Mike and Mary Payton. They own the property. They are joined by their daughter, Alicia Rusher. You will hear in a few minutes from Mike and Alicia. And then, as you know, we have our not so secret weapon, Dr. Peter Finley Fry, who has, when I say 33 years in practice, he of course laughs and he beats me by about 12 years, I think. He has been a land use planner here for many, many years and served for many years on the Multnomah County Planning Commission, so he understands these issues. That is us. So you are presented with a record that's got quite a lot of verbiage in it. I very much appreciate in that context the way in which your staff laid out specifically the main question before you, which is the practicability issue. Because the application is complete, I stress that we view ourselves as here. We love the sound of our own voices, but we want to hear your questions. If you have questions, and they don't have to be softballs, believe me, we want to take your tough questions because we want to be responsive on these very important issues. So staff, I think, well went through the practicability test, real world considerations, not theoretical possibilities. And of course, the notion that farm use, inherent in the term farm use in this state, is for the purpose of obtaining profit. I am going to not bury the lead here enough to let you know that we are in absolute disagreement with the notion that there's anybody around here farming profit, and anybody around the area of the site farming for profit. We went through the 6 discrete factors in our application. Appreciated the questions about soil quality, and I would stress that I believe opponents to the application are sort of trying to piecemeal it, and I don't mean your staff on this, but the opponents, Thousand Friends and DLCD, are sort of trying to piecemeal the issue and say, well, profitability is not determinative. I agree. Soil quality, not determinative. I agree. But if you take the 6 factors that we laid out all in total, then we do believe that we've reached the impracticability standard. So staff points out that these factors have been disputed. In my mind, they are not disproven. And I'm going to venture that, to me, I'm speaking here as a lawyer, not a farmer. I probably broke my mother's heart with that. I haven't had any dirt under my nails in 40 years, but as a lawyer, I just note, isn't some evidence of impracticability the fact that this site hasn't been farmed in 45 years? And on that issue, I'm going to turn the microphone and hopefully the camera over to Mike Payton. And as I do so, what I would stress to commissioners is you are presented here tonight, I think, with the distinction between sort of aerial, we're tending to, aerial photography is great and Google Earth is great and we all use it, but it doesn't end there. And these investigations are so much more meaningful when we go to the site. We saw that on the soil quality issue, right? Everybody knows that we have these maps created in the 30s by the SCS, but you find out different information when you go on the site, and we found that here. So the applicants, particularly Mike and Alicia, are going to speak specifically to what they have observed and experienced on the property. Mike, are you ready to go?
Yeah.
I think they have to allow your screen.
Yep.
Maybe.
Well, I think they can hear you.
Okay.
Yeah, they can hear
Just
you.
talk.
Okay.
Yeah.
Hi, I'm Mike Payton. I and my 45 years of happy marriage, Mary right next to me. We own the property at 40822 Southeast Allgaier Road, Clackamas County, Sandy, Oregon. our whole lives, we lived in Clackamas County. Both Mary and I went to Concord Grade School and Rex Putnam High School. Our two kids, a boy and a girl, both went to grade school and Clackamas High School in Clackamas County. My wife and I, we found this property by taking a drive out in Sandy. Of course, we're retired. We're kind of looking for a nice place to retire, have stuff to do. And the property, let's see, we felt we could build a legacy for our kids, family, and future on the property. We needed a place to live first, but allowing our family to build, have small gardens, chickens, livestock, having our children and grandkids close to us would be incredible. We also feel lucky we have very good neighbors. I've sat down with two of them, had coffee, very nice people, talking to them. They're just very nice people. And, that's about what I got to say.
So
Lisa.
I kind of want to.
Do you actually want, because
Okay,
the camera's
yeah.
not working, do you want to sit here?
Sure. Sorry.
Put you on
I'm
camera.
not sure. Oops. Hi, I'm Alicia. I'm the daughter. So, I have talked to multiple neighbors in that area, and none of them are, I guess, farming in a profitable way. We do have a neighbor that has, they're like retired racehorses that they like take care of, because otherwise the racehorses are usually put to slaughter. And the neighbor that has the 29 acres right next to it doesn't actually hay. They just cut their field for farm mitigation. So, or not farm, fire.
Fire mitigation.
Sorry, I'm a little nervous speaker. But yeah, so I just kind of wanted to point that out. Everybody there is just kind of families that have little recreational farms. I mean, they're there with like a couple horses or, no hay. They actually have hay brought in to their horses because there's no like actual good hay there to like farm. So, yeah.
So you've got horses feeding on hay in the neighborhood.
Yes.
None of that hay comes from the
No,
neighborhood.
no.
It all comes in from outside.
No. And so Tim, he's one of the owners next to the property, and we've talked to him, and he actually has one of his family members come in and just cut his field. But they don't take hay out of it because it's just, the hay is just not, I guess it's just not healthy for any livestock to actually consume. They just want to get rid of it. So it's like not sitting there as a fire danger. And then the horses next to Tim, they actually just back into my dad's property just to be able to get their hay trucks in and out of there to like deliver hay to their site. So it's a lot different than what you see in 2018. Like if you're actually there, it just kind of looks like a neighborhood. So yeah.
Okay.
That's what I wanted to say. But
Thank you so much, Alicia. Mike, did you have more to address on this specific issue? Go ahead and take the seat, just so they can see you're just so they can see you're a real person.
Okay.
They don't think you're AI generated.
Okay. Hello. Anyway, yeah, what Alicia was talking about was what's in that neighborhood. And when my wife and I originally drove around in 2023 and we spotted this property, we thought, what a nice neighborhood. And we didn't see any crops. All we saw were horses and cattle. And then across the street is some chickens. And we thought, well, this would be a nice place to build a house, to retire to, sell our house we have now. And we could have fun farming the land there, have some cattle and, some fun things to do for retirement. I've worked all my life since I was 14 years old. I figure I'm 69 years old now. I'd like to have something fun and nice and comfortable, kind of get away from the residential area that we lived in, which was real close, home on home. This really, it's beautiful out there. The property's nice and flat. It's really hard to resist. I mean, we really enjoy being out there. We visit it with our dogs. We see coyotes, we see other animals out there, which is real fun. So that's kind of our intention is build a house. Kids would just love to come out. We could get a couple of horses, maybe some cattle, something to kind of keep ourselves busy, I guess. And
But Mike, on the hay issue, did you have hay cut from the property?
no, we had to have it mowed. Right now, I actually have a picture of it. It shows all the weeds. What happened was apparently back in 2018, maybe they hayed it, but what they did, they let the field go. So there's nothing but weeds, clover. You can see flowers out there, dandelions. So you're talking 15 acres of nothing but weeds and just messy ground. That's why I had the soil sample done, which showed 52% of the soil non-high value. So, and then the other part of the soil that was 40-some% had a mix of the bad soil in it. So there was kind of something said there. If you got your hands on that soil sample information, you would see really about this soil, which would require a massive amount of, you'd have to kill all the weeds, just like you would on your lawn out front. You'd have to fertilize it, possibly bring topsoil in. It's just a mess. I have a picture of it. I wish I could show you, but it's not very nice. But it's good to build a house, put a fence around, have cattle. Like what's in a neighborhood, nobody's growing crops in the neighborhood. Pretty much everything's either cattle, and horses. Race horses is real popular apparently in that area. Talking to the neighbors, like I said, I sat down and had coffee with a couple of them, and they were talking about the race horses that were going to be slaughtered, and they would take them. Really no money in it, of course, but these people felt they didn't want these horses killed. Well, I wouldn't mind doing that either. It'd be a fun, kind of nice thing to do. So,
Okay.
Anyway, that's
Thank you, Mike. Barring any questions, we would turn it over to Dr. Fry.
Thank you very much.
So, thank you for your time. I'm Peter Finley Fry. I actually do own 16 acres of land on EFU protected farm, and we were able to get our dwelling approved through a conditional use process, which does not exist in the state anymore. Now you have to prove that you can produce income off of your property. And the frustrating thing to me is that everybody that's defining farming doesn't seem to have ever actually farmed it before commercially. And I deal with commercial farmers, and they have large lots and they have businesses. And I was surprised by the fact that the county's approved 15 dwellings that met the income test. The income test in Oregon right now is you have good soil. You have to show that you make $80,000 a year, as Martha pointed out, 2 or 3 out of 5, or 2. If your soil's not good, you got to make $34,500. On my farm, there's no way I'd produce more than I do a schedule after every year, IRS, and I never make income more than $2,000 to $4,000 and that's obviously net, but even gross, it's almost impossible unless you're really a business person. And many people have been able to get through I call it the Christmas tree loophole, because in Oregon, we call Christmas trees an agricultural product, not a timber product. And so many of these dwellings have been approved through people planting Christmas trees on their property. So I am a little surprised by the fact that you've apparently approved 15 dwellings that somehow met the income test. Basically, the question here, to me, is what is farming? And I believe, and I'm a planner, not a lawyer, and unfortunately, most of the stuff is being defined by lawyers who have never farmed. But so I make it more simple in my mind. There's either commercial farms, and I work with a lot of them on Saugus Island in the valley in Central Oregon. Central Oregon farms can be thousands of acres, as you know. In Eastern Oregon, they could be even larger. In the Willamette Valley, because we have such good soil, you can produce more on smaller lots. FYI, we don't buy our hay from Willamette Valley. Our hay comes from Tye Valley in Central Oregon. In fact, most of the hay or alfalfa that we feed our livestock in Western Oregon actually comes from Central Oregon, not Western Oregon. So there's commercial farms, and then there's family farms. And the family farm is what I've got. It doesn't produce any real money. We have 80 trees, orchard, and our bears are very happy every year because they get to eat all of our apples that fall off the tree. We do sell at produce stands, but again, you're talking about several $1,000s, not $34,000. And it's, I can't really explain how those things got approved. And I'm not going to cast dispersion on those things. I'm just telling you I'm personally surprised based on my experience with real farmers and how real farmers have to struggle to create produce stands. And as you probably know, statewide, the governor recently stopped a process where the DLCD was going to limit the ability of farmers to sell their product off their farms, retail. And there's a huge backlash from some of the farmers that I work with on Saugus Island. And the governor stopped that process from DLCD. So there's clearly a conflict right now, legal conflict. But basically, my view of this is that this property cannot be farmed for commercial profit. It's simply, in my view, not possible. And I've written that. I'm not going to, you can read what I've written and you can ask questions. And basically, what I've argued is that the property is going to be a vacant lot, like you see in Portland, covered with trash, because no one's going to farm it commercially because it's simply not feasible. You can't, there was a discussion about spraying, and obviously we run an organic farm here, but spraying is a real issue. And DEQ, Department of Environmental Quality, utilizes what's called a risk-based analysis. For example, selenium, which is a natural occurring mineral, is commonly used to fatten cows and get better milk. And so farms are often have selenium put onto their property. However, selenium's toxic, concentrated. So when we've converted farmland within a UGB in Molalla, we have to show that that land is going to be used for industrial land and not residential land because of the toxicity of the selenium. So the Thousand Friends letter, they kind of blew off the issue of pesticide and herbicides. but it's a real issue legally with the Department of Environmental Quality. Another issue was the transportation, and I do understand staff's concern. It really wasn't fleshed out, but I didn't think it was important to have the engineer go to that level of detail. So really, to me, it comes down to the right to farm, which both DLCD and Thousand Friends pointed out. In Oregon, we have the right to farm. In fact, there is farming in the Inner East Side Portland. I've seen it inside of warehouse buildings, and they are farming and they are making profit. They're making a lot of profit, and they're not on farmland. They're in a warehouse building. So we do have a right to farm. However, most farmers, and certainly me, are not going to go out and hire attorneys to protect our right to farm. What really happens is we end up with a neighbor complaining about the spray that's going on their property, or the horse that broke through the fence, or the cow that broke through the fence that went over and, went to the bathroom on their front porch or whatever. And so then you're dealing with a neighbor. And so instead of you farming or living or enjoying your life, you're constantly dealing with complaining and complaints, which are all legitimate. And so the issue of the right to farm from a legal point of view is really not relevant. And so what I was trying to explain in my memo is that, one, this property is not commercial farmable because of the surrounding situation of the small lots, the dwellings, the traffic, all these factors. And second is that it would not be farmed at all without a dwelling on it, which meets the comprehensive plan requirements. So there's really two lenses here. One is the exception issue, and I believe the exception issue really is related to the state law, where we're trying to protect profitable farmland, and I believe that. And in this case, I've presented to you what I believe are the facts, that this land is not commercially profitable, therefore the exception is justified, and this property should not receive the protection of the EFU, the automatic tax exemption that comes with the EFU, and all the things that protected zone allows. That's the first part. And the second part is, if it's not to be protected, what should it be? And I believe your comprehensive plan policies clearly point to the 10-acre rural residential, and I believe that property and that use is consistent with the surrounding uses that are dwellings that do have farm activities on them, but they're not commercial farms. I don't have much more. I can obviously go on and on, but you've already listened to plenty, so I'd be happy to answer questions. That's it. Thank you very much.
Okay, thank you for your testimony. Do we have any questioners of the other commissioners? I don't see any hands raised yet. Oh, here we go. Commissioner Lopes, you have a question?
Yeah, and either the owners of the property or their attorney, who if he speaks for them, can answer these. Prior to purchasing the property, which I believe was stated as 2023, was the due diligence done to make sure that the property was buildable as it was, that a house could be built as it was, or was it just purchased without any knowledge?
I think you're on mute.
Oh,
There you go. Go ahead.
yeah, I did do diligence on it. I'm sorry. I looked around. When we first looked at this property, we saw homes, we saw cattle, we saw kids across the street, homes on every lot in the area. Without any reasoning, I figured okay, here's a nice piece of land. I'm sure you could build a home on it. The realtor even suggested, I know you could build one home, but you're talking $80,000 a year for 2 years. And then again, they were talking about that expense. Well, the neighbors next door said they paid $665 a year.
No, they make.
They had to make it. So the difference was back in the days, it was $865 a year, and now they brought it up to $80,000 a year for 2 years, and they don't specify if you're talking 100 acres or 15 acres. They still hit you with that 80,000. So, and then looking at the property now, like I say, it's weeds. Somebody let it go. There's no, I mean, you'd have to come in with spray trucks with wands and spray the whole property, kill everything and start over. And that was the thing about the spray. When I talked to the neighbors, I sat down and had coffee, of course. That was a main concern, the environmental part of it, being it's kind of squeezed in between cattle, horses, which surround my property, which is real, to me, it's real concerning. So,
But they're just asking if you knew ahead of time. And when you first bought this property, we originally hired a planner that we don't work with anymore, and she was very confident in it working, and that we were going to be able to at least get a house on it. And so we kind of rolled with that. And then also just looking at all of the developments around the property, when you drive down that road, if you haven't before, it's a ton of houses all around. There's brand new houses, and there's houses that literally are on half-acre lots. So it wasn't something that, when you actually look at it, would look like it would be in the middle of some huge ag zone that prohibits you to build a house on.
exactly.
It's like when you're driving down the road, every single parcel, besides this one parcel next to us that has this tiny, skinny little road, every single parcel has a house on it. Every single one of them. So, and they don't farm out there. Like if you actually go down there, you would see they do not farm at all.
Okay.
So did you find out that you couldn't build a house when you went to submit something to the county, or how did you find out?
Yes.
Yes.
After purchase, obviously. Okay. And you've had it now for a couple of years, and you are on farm tax deferral. So you have to be farming to get the farm tax deferral. Have the property assessors come out or anything?
No. Well, they came out and I'll raise the taxes maybe $10. Nothing's been done out there. The property's just there. Nothing can be done on it. That's why the idea of a home and then developing some of the property behind it was my idea of some kind of farming of some kind, cattle. Like I say, I'm real excited about horses and cattle, and I thought this would be a great place to go. But it's very deceiving. If you look around, nobody would think that you would have to farm to build a house on this property with what's the surroundings look like. And even the people I talked to. Okay, thank you.
All right.
Okay. Yeah, I speak from some experience. I have timberland, and it took me a year before I purchased it to find out, actually with a team of attorneys, to make sure of all the requirements that I had to do to keep it in forest tax deferral and other requirements. And so that's why I was asking, because I've kind of gone through some many years ago, but I went through some of that myself. But believe me, I wasn't going to buy it if they came up with something which I knew I couldn't accomplish or meet. But anyway, that's why I asked. Thank you very much.
Yeah, thank you.
Okay, Commissioner Wilson, I see you have your hand up. You're on mute.
Oh, you're on
Okay,
mute.
I'm unmuted now. Mr. Padden, I appreciate all your comments, and I can relate to that. I was raised on a 100-acre farm in Louisiana, and it wasn't for profit. It was for just for us to do it. Our money came in from other sources. So I can understand where you're coming from, and having this requirement that you have to farm this land seems a little ridiculous to me because of the size of the 15 acres. I was raised on 100 acres, and we weren't making profit off of that. But anyway, I understand from what you said that primarily what you want to do here is put up a house and retire there and possibly raise some livestock or what have you. And I'm in total agreement with that. Mr. Fry, you did a good job on putting all this information together, and I read it. It was quite long, but it was very extensive, and I really appreciate it. And let me say this. We've got a lot to do here in this country, and working towards getting people back to being people is what's important. And I thank you very much, and I'll turn it over to somebody else. Thank you.
Okay, thank you. Commissioner Wilson, anyone else have any other questions of the applicant? No? Any closing remarks before we move on from the applicant, or are we good? I guess we're good.
Pardon me, Mr. Chair. The applicants would like to address the ag building?
Yeah, we never put it up, so it's not, there's no like farming going on, there's no ag building there. It's just, yeah, outstanding. We were just told we could apply to get a building, but after going through all of this stuff, we're kind of, on a standstill if we want to do that or not.
Okay. And while we're on it, Mike, as I said, the staff report referenced an RV on the property.
Yeah, the RV is my RV. I used to have it stored, and I bought the property. I thought, well, why pay the big fee every month? I'll drag it out there, throw it in the middle of the property. So when we take our dogs out there and run around, we can open the door, maybe go in and have a cup of coffee, leave the door open, look at the view, let the dogs run. And then when we're all done, then we just kind of lock it up. And
so it's a glorified doghouse. No one is no one is living in the RV, just to be clear. Thank you.
Okay, Commissioner Fowles, I see your hand is raised.
Yeah, thank you. I just want to clarify off Commissioner Lopes's comments because I don't think I've really got a clear answer kind of on both of her questions about when you were purchasing the property, this was clearly zoned as ag. Did you not do the due diligence, or did you buy it fingers crossed hoping that it would be able to be zoned different with the assumption you were going to build and retire there?
yeah, I did go to the county and checked a couple things, probably not enough.
Okay.
And then again, the idea of the farming that I found out later, when I went up and talked, there was nothing about the farming that was told to me at that time.
And the professionals.
What's that?
The professional opinions we've had, along the way that we trusted that probably shouldn't have.
Right, the professional people we trusted along the way. When you're dealing with realtors and, of course, everything's the best you can.
Correct.
Best thing you can do. So what I checked and what I heard from them was good. And I thought, okay, good. We can come out here. We can build. We can put fences up. We can it'd be wonderful. And I went around and I talked to all the neighbors, even one up, maybe a block or two up the road. I wanted to get the feel and find out about what's going on. Nice people, like I say, and that there was a history of the Allgeiers, I guess, that owned all that property. Well, there were 3 of them still in the neighborhood, which I talked to, and I got all the information, and I thought, okay, this is wonderful, you know? So it was hard to resist. It's a beautiful piece of property, nice and flat, other than all the weeds. And like I say,
Yeah, I actually know the area well, so I know what you're talking about when you say you drive up there and everybody has it. I understand that. The second part of her question about the farm tax deferral, how are you guys qualifying for that if you're not farming on it? Because my understanding of that is you have to make a certain number, whether it's $800 or $1,000, or I think it's $100 an acre or something like that. How are you qualifying if you're not currently farming it? Because a lot of this is about you not farming.
automatically given, I guess, just stepped right in and here's your bill.
Okay.
You know, I mean, I said, well, it could be more if you had a house on it, I'm sure. Once a home's put on there, I'm sure it goes into the normal.
Question.
Good. Yes.
So, under the protected zone, you have to farm your land. You don't have to show any profit at all. If you're not in a EFU or CFU zone, you have to prove that you make a profit in order to get the tax exemption.
Okay. Okay. I was just curious because they kind of contradicted each other.
Yeah, I didn't understand. Like I say, it was just given to me the bill, and I thought, okay, well, that's not too bad, you know.
I wish mine was that way. Well, thank you for your answers. That helped out a lot.
Yep.
Absolutely. Thank you.
Okay. All righty. I guess we will now move on and offer an opportunity for any representatives of a community planning organization or hamlets to speak. I assume we don't have any. Okay. Does anyone wish to speak in favor of the application? So that would be any neighbors or friends or whoever that might are here to speak on your behalf. I'm assuming we don't have anyone. I don't see anyone listed. So, okay. Similarly, do we have anyone who wants to speak in opposition of the application? Nope. Okay. And do we have any neutral testimony that people want to offer? Okay. Since there wasn't any comment, I'm assuming the applicant doesn't wish to rebuttal their comments, but I'll still offer the opportunity. No, good. Okay. And what about staff? Is staff wish to provide us a rebuttal for anything? No?
Yes, I would like to make a couple of comments,
Okay.
and I will try to make them quick. I think that this is an interesting and difficult conversation. I understand that and appreciate the intent of the owner who bought the property. My understanding, at least initially, was that it was to divide and put 3 houses on. But now under the FF10, it would potentially be 1 house. And I can appreciate the conversation about how difficult it might be to farm this property, although I don't know for sure. I think it's very clear. In 2018, it was in hay. When you look closely at the aerial photos, it wasn't just somebody clearing a field. It was in hay. I don't know if they made a profit or not. I don't know if the neighbors who have horse boarding actually make a profit or not. That's not really the standard. And the standard here for an irrevocably committed exception is that there is something about the neighboring properties that makes it impracticable for you to farm your property. I've heard there's horses, those are farm uses. I've heard there's cattle, there's farm uses, those are farm uses. Other livestock, there's clearly a history of some other sort of nursery stock or something in the adjacent parcel to the south. And so there are farm uses. It is practicable for other adjacent properties to farm, and there hasn't been any evidence shown that whatever is going on in those neighboring parcels has made it impracticable for this particular parcel. Rather, I've heard that it's too small, that maybe the soils aren't as good. Those are all arguments that are sort of leading to this wasn't properly zoned agricultural land. That's not the standard here. That's not what was applied for. The state does have a process for that type of an argument outside of the goal exception process, although I would expect it's extraordinarily difficult with primarily class 2 and 4 soils on your property and this demonstrated history of some sort of farming activity. And so it's as much, it's not that I don't believe that the soils may not be what we know, all these class 2 soils that were originally mapped on the property, but the standard for this particular application is that it is irrevocably committed to non-farm uses because of something, development or something happening on adjacent properties. And so I think it's also interesting what Mr. Fry, Dr. Fry, apologies, said about farm tax deferral, which I didn't know, is in a farm zone, you don't even have to make a profit to be in farm tax deferral. That implies that farming in a farm zone isn't necessarily required to be profitable. I don't know why it would have to be defined as a farm use under ORS 215-203. And so those are essentially my comments. I have 1 to 2 other comments. One is, because the soils have been mapped as predominantly low value now, there may be a route through EFU. I don't know if it would meet all the criteria for a non-farm dwelling. It's not typically as available for properties that are all high value farmland. It involves a different analysis. It would necessitate the entire property be taken out of tax deferral. It's maybe a possible option for one dwelling, since the applicants seem now be willing to that didn't make sense, seem to now be willing to accept only one dwelling rather than the 3 that they had originally applied for. And so we in planning are happy to talk to you a little bit more about that potential and see if that analysis is maybe likely to be successful. But I still feel that the standard for an irrevocably committed exception has simply not been met in this case. So that's that.
Okay.
That's all I have to say.
Thank you for your rebuttal. Commissioner Wilson, you have your hand raised, I see.
Martha, thank you for all those comments and the work you've done on this. I'm sure this has been one of your tougher jobs. What options do we have here for the applicant? You went over a few before, but I think we need to get some very specifics here. We don't want to break the law. We don't want to break policy. We don't want to break ordinances or whatever. But I personally see some issues here that really need to be addressed. We have a family here that's looking to, do better and help the community. And yet we have certain things here that are restricting them from accomplishing that. And, I don't want to change the rules or whatever. I'm just looking for some alternative for them to get what's best for them, what's best for the community, what's best for all of us. Just some comments, please.
Could I interrupt before you? We're kind of getting into deliberations here. So, so I appreciate where you're coming from, Commissioner Wilson. And I think it's an appropriate thing to discuss when we get into deliberations. So if anyone has, and so there is an opportunity for us to ask those kinds of questions during deliberations. So I'd kind of like to get through the applicant aspect and the process before we get into that discussion, if that's okay with you. Okay, thank you. How about, okay, are you, and I see Commissioner Lee's hand went down too. All right, thank you, folks. I know we want to get talking about it, and we will. Just give me a second. But I do have to follow this format. So with that, next, my to-do list here is there any person who wishes to request an opportunity to present additional evidence, arguments, or testimony regarding the application? I'm assuming. You have something?
Well, can you give me just 30 seconds to
Yeah.
chat with my client?
Sure. Oh, you're back. Okay. Yes. Are you there?
Yeah.
Yeah. No, I'm just asking for, let me just ask my client. I have to get my client's authorization to any, you were asking about an open record period or continuance?
Yes.
Okay. And I very much appreciate you doing that. Let me just check with my clients very quick. Okay.
While they're doing that, I'll ask my question to
Sure.
Martha and Jennifer. We received this information this morning, this additional information. Martha's barely had time to even review it. Certainly, County Council has not had time to review any of the legal issues that have been brought up. Would it make sense to keep the record open so that we could have further discussion once parties have had a chance to fully review, digest, analyze, and respond to all of the issues, both legal and code-wise?
Yeah, and you brought that up in your email as well. So it's a good call out. And to be quite honest, I'm not quite sure whether this is something we can do in the testimony or we have to do it during the. So one would think, given your comment, that we're asking to keep the record open for them to provide additional testimony, which, so first, let's see what the applicant has to say, okay? Anything?
Thank you. Am I on? Okay, I would first note that I think the job of everyone here, not on the commission, is to get the commission as much information and as it thinks the best information possible to make its decision. And I appreciated Commissioner Wilson noting that, quote, this is a tough one. And I got to tell you, I absolutely want to convince Ms. Fritzie of us. She laid out, hey, I'm not convinced by XYZ. Please understand that we only had 6 days, and I realize we submitted the application, yes, but the way in which this whole land use process that Ms. Hughes and Ms. Fritzie, Dr. Fry and I have to live with professionally 24/7, it gets so compressed in this period that we had only 6 days to try to respond to the staff report. We did the best we could. I think we would love the opportunity to be more responsive if you're willing to give us that opportunity. I think by law you have to give us 7 days. I would ask for something more like 14. I would like to try to go out and interview more formally, not just neighbors, but see if we can find more about the history of the property. But I don't know if in asking that, I don't want to throw, you guys have agendas and you guys have other folks on agendas. And I certainly don't want to throw a major monkey wrench into Ms. Hughes' calendar of everything she's got to deal with. But that's just my sense of it. Thank you.
Okay, well, this is an unusual circumstance, so and new for me anyway. So I'm gonna maybe look for a little help on how we might want to approach this. I've got a couple of thoughts that I might throw out there first of all. One is we could close the hearing. We could have our discussion. We could express our concerns and what we feel needs to be addressed for us to deliberate. And then, but that could be forwarded on to a recommendation to the county commissioners who actually have the final authority. We're just a recommending body. So that would be one option. Another option would be to say, okay, let's keep the hearing open and we will give an opportunity for additional information to be processed, and then we'll reconvene at a time we can agree on, which would probably be in a couple of weeks or whatever works out. So those are kind of how I see it. I'm open to any other thoughts as to how we might approach this. And then there's one, I guess the third option is I could poll the commissioners and see, well, how many of you feel you need additional information to act on this? But I'm not sure how this works. I guess we could take a vote while the record is open on to whether we want to continue that as a starting point. Am I following the rules here, Jennifer?
So, admittedly, the way our planning commission works process is a little murkier. What Mr. Wyman was alluding to is that you really generally in a public hearing situation for land use must leave the record open for 7 days if any party asks for it.
Okay.
It's a little unusual because the planning commission doesn't make a decision, right? So but still, we have assumed in the past that those rules do apply. It's just normally we don't get a lot of folks asking the way they do when they're in front of the land use hearings officer. So I think to be safe, if the applicant wants that 7 days, we should give it to them. And the way that you then it gets sort of complex from there because they can request 7 days. Then there's this 7 days where anybody's supposed to be able to sort of potentially rebut whatever's come in. And then the applicant always gets the final 7 days for their final legal argument. If we go through all that, it takes 3 weeks. And then you have to try to somehow really do all that in writing so that we don't have to have another hearing, because then you could just have this, perpetual, right? Mm-hmm. And then you'd need to come back and make a decision based on whatever's in the written record. So that's one option. You could do 1 week, 1 week, 1 week. And then that would push this out to probably February 23rd would be your next hearing date that would work with that. And we would push the board hearing out. Alternatively, you could just continue it to February 9th, which is your next meeting, and you are open. You could just essentially leave the hearing open, leave the record open, and we could sort of pick up at the next hearing, and you could take additional oral testimony, which it appears is most likely to be just the applicant. We don't have anybody else here tonight. So if you wanted to do that, I think that would probably be acceptable. I do think we should let Mr. Wyman respond to what I said, though.
Okay.
Well, I appreciate that. Again, I would just first of all, everything Ms. Hughes said is spot on. She obviously knows her stuff. We would absolutely love the opportunity to come back before you and bring additional information. Nothing will be served by that. I believe in 14 days we can find out more specific information about farm use on the site, which I think is relevant, as well as adjacent lands, more specific information. If you would give us that opportunity, we would take it.
Okay. I see a couple of other hands raised, so I don't recall who was first, but I think it was Michael, Commissioner Wilson. So you another comment, Michael?
Yeah, Tom. I would like to make a motion that we table this issue for at least 14 days, a date to be determined, and then reconsider it in another meeting.
Okay. So we have a motion. Do we have any seconds? I do see some other hands raised, so I'm kind of on the fence as to whether we should let them speak before we vote.
Question.
Yeah.
Commissioner Wilson, did you mean continuance? You said table. That's a different function than continuance.
I mean to continue it, but table the motion for right now until we can consider it in 2 weeks, at least 2 weeks, longer if necessary.
Thank you.
So we do need to set a date certain, or the staff's going to have to re-notify, which is potentially expensive. So it would be better if we could identify a specific date and then we just announce that now.
Would it be okay if we just do this a little more informally and kind of get a rough poll as opposed to being a motion? Because I see other people have raised their hands and I haven't had a chance to hear their discussion. I mean, we're kind of in deliberations here in a sense. And so if it's okay, could I hold that on that motion and let these other two commissioners say what they wanted to say before we vote on anything?
Absolutely, Tom. Absolutely.
Thank you. All right. Commissioner Murphy, you had your hand raised.
Thank you, Tom. I just want to ask Jennifer if the Board of County Commissioners hearing is allowed any more additional information.
Yes, our board hearings are what you call de novo. So people can submit all kinds of new information if they want to. Yeah.
So we can reach a decision today. And the next hearing will be the Board of County Commissioners. And if there's additional, then they can make that decision.
So you could, but I think I think the issue here though is, this is a land use hearing and I think the sort of conservative approach is to assume that the same rules apply, even though you're not making the final decision. And that's where an applicant, any party can ask for the record to be left open. And the decision maker has to leave it open for a minimum of 7 days, at least leave the written record open a minimum of 7 days. So, in the instance where it goes to the board and it all starts anew, it might not be some sort of, end all be all procedural error if you just decided to make a decision tonight. But I guess we have no opponents here saying they don't want to continue this. And we have an applicant who's asking for more time. So it seems to me like I would certainly recommend that you continue it out to the 2 weeks or whatnot.
Yes.
Murph, we have to keep in mind that we're just making a recommendation.
True.
We're not deciding anything. We're just making a recommendation to the Board of County Commissioners.
I understand that 100%.
Yeah. Commissioner Satter, your hand is raised.
I just wanted to give some feedback to the property owner because I was looking into this deferment, and when the use changes, that there will be potentially up to 10 years of the deferred amount will come due. They could get billed for that. So I want them to think about that when they're making their decision as well.
Okay.
And I did look at it for the other commissioners when we're thinking about this. It is assigned when it's applied for, which they've stated that the previous property owner probably applied for it because they had it. And it is usually with the county property tax assessors, when you get a deferral program, you have to reapply every year. You at least have to file a paperwork every year, right? And this type of deferment is an exception where it is only done at the time of the application and then when there's a change of use. So I just want to add that stuff.
Thank you. And Commissioner Lopes, I see your hand is raised.
Yeah, just to piggyback on Commissioner Satter's remarks on the tax deferral, I'm in timber tax deferral, so it might be slightly different than farm deferral. But when I purchased my property, I was told that if I took it out of timber, I'd owe 20 years of back taxes, which would be astronomical. And there was writing put into the closing documents that the prior owner would not be responsible, I would be. And now, of course, if I were to sell it now, my attorney would put into that I would not be responsible and that the next owner would have to pay the 20 years of back taxes if it was taken out of the timber use. So I'm not sure if it's 10 years now, and farm may be different than forest, but there is a liability when you have to be careful purchasing tax deferred land. There's a liability there, and it doesn't sound like maybe these folks understood that when they purchased their 15 acres. But anyway, yeah, I just wanted to piggyback on that. Thank you.
Okay. All right. All right. So anybody, okay, back to Commissioner Wilson's motion to, let's see if I can paraphrase this properly, to keep the written record open, to postpone acting on this until the applicant has had a chance to provide additional evidence. And so we're talking at least 2 weeks out that we would reconvene. Do I have that right?
Yes, you have that correct. And I want to make sure that when we do reconvene, that the staff has put together what issues may come up with our policy changes that this may affect. We're looking at something a little different here, and so I would hope that the staff and Jennifer and your people would look at this if we do okay this, that we're not affecting future issues regarding this type of situation.
Mm-hmm.
So I think we're probably going to need some clarification of the motion for staff, at least.
Okay.
And we need to know specifically how long is the written record staying open? Because you're otherwise going to get yourself in the same box of potentially getting stuff on the day of the meeting.
Okay. Well,
and then do you want to take oral testimony again at the next hearing, or just close the written record at a certain date and then deliberation and decision only during the hearing?
Okay. Okay. Good point. Commissioner Satter, I see you had your hand raised. No? Okay. Well, you're showing as your hand's raised. No.
Oh, sorry. My
Okay.
question, I forgot to unmute, would be for staff. We have a meeting scheduled for February 9th, and I wanted to ask, what we have going on for that meeting, if you know.
Correct. So at the moment, you have nothing on your agenda for February 9th. So if you wanted to set this over to that date, you could. I know Mr. Wyman has suggested 14 days. I would probably suggest that you maybe close the written record in a week, and then so you can review everything. But otherwise, February 23rd, we had some study sessions we were considering doing, but those could shift. So if you'd rather push this out 4 weeks because it gives them a little more time and et cetera, that's also fine.
Commissioner Founds?
Yeah, I just wanted to suggest maybe pushing it out till the 23rd. Give them more time. Because I just feel we're going to come into the same situation again in 2 weeks.
Okay.
That's all I had to say.
All right. So are you proposing to amend the motion to be that specific then?
Yes,
Okay.
to push it out to February 23rd.
Okay. So so
I'm
the
I'm okay with that, Tom.
Okay.
And I just want to make sure that, we come into this meeting with some good analysis and also give the opposition time to prepare for anything they want to respond to.
Okay. So if I understand you correctly, then you are advocating for another full public hearing with oral testimony, or are you just, or are you content, are you fine with just it being submission of the written record and we would just
No,
act
no,
based
no,
on-
no, no, Tom. Tom, I want to hear from the opposition too. We're giving the proponents here a good time to prepare. We have two entities that were asking for this to be denied. And I think that they need an opportunity to respond as well.
Okay. Okay.
So, and I should probably clarify what I said before. This, if you're going to go ahead and have a hearing and take more testimony, then we're really not going to be able to close any record, because in theory, they can have final argument and all that after the next hearing. So you could either do, I think, 2 weeks, for example, for the applicant, for any party to submit information, another week for response, another week for final argument, and just deliberate and make a decision, or some variation of that would fit within 4 weeks. Or you just continue the hearing until the 23rd, don't close any kind of record, and maybe strongly suggest to the applicant that it would be wonderful if they could submit the written information at least a week in advance of your hearing, and leave it at that.
Well, what do you recommend, Jennifer?
If you want to hear from the applicant, which is what I heard you say, Commissioner Wilson, if you want to have more oral testimony, then I would suggest that you just move to continue this hearing, leave it open, and continue the hearing until the 23rd of February at 6:30.
I'm okay with that.
Okay.
I second that motion.
I think what I've got, if I think
I'm sorry,
So
we
what-
had a second on the motion?
we haven't yet. I think we're still,
Yes, I did.
I guess
Commissioner Lee? Was that you?
Yes.
Okay, so I want to make sure I state the motion correctly, or do you have it down, Darcy? Would you like to try to explain it to me?
Well,
Jennifer
excuse me?
What Jennifer said.
As it currently stands, Commissioner Wilson moved to continue the hearing to February 23rd.
That's it.
That is it.
Okay, so, but I also heard that we want to, so that would imply then that the public testimony is still open. We are not closing that. But I guess what I want to clarify, do we want to dictate that we get the responses within a certain time frame so we aren't faced with another situation like we were faced today, where we got testimony the day of the hearing? I really like to avoid that again. And so if it's helpful to state a specific time frame that we want this to, that would make sense to me, as opposed to keeping it open right now.
I think you can't really close it because you're going to have another hearing, but I think that maybe Mr. Wyman could express whether he thinks his client is willing to provide all the information, say 2 weeks from now, maybe 3 weeks at the latest, so they can have it for at least a week in advance.
Yes, yes, thank you very much, Ms. Hughes. We absolutely, we understand. We understand that submitting in the morning of the hearing, which I can't remember the last time I did that, and actually having staff go through it is Herculean, and we do get that's suboptimal. So we will we will commit to get this information to you well before the hearing. I even have some inclination to waive final argument. I don't see the need for more legal briefs here. You know, I mean, as much as I love it, I just don't think it's going to be informative for the commission. This is coming down to factual issues. I think we want just to be specifically responsive to Ms. Fritzy's stated concerns.
Okay. All right. So I guess the motion is, as was stated, that we'll extend the hearing to the 23rd, and we hope that we get all of the materials in a timely manner so that we can act on this item at that meeting. Okay. So we have a motion and a second. So can I get? Yes, I need to take a vote here. So I'm going to just go down the list based on how I see it on my screen. Commissioner Wilson, or excuse me,
Yes. Yes.
Commissioner Lopes,
Yes.
Commissioner Murphy,
Murph, you're on mute.
you're on mute.
No.
No?
No.
Okay. Commissioner Lee,
Yes.
Commissioner Founds,
Yes.
Commissioner Satter,
Yes.
and Commissioner
Found.
Founds.
I already did it, but yes.
Yeah, no, my list keeps moving around on my screen, so I'm losing track who's.
It'd be Lopes.
It's just
This
you,
is lo-
Tom. Everybody's voted besides you, Mr. Chair.
Commissioner. Okay, everyone's it's me. Okay, I'll vote yes also.
Tom,
Okay.
Tom, I have one. It seems like we had some legalese in this discussion and all the stuff we sent. We might need to see if Jennifer can get our county attorney to take a look at some of this stuff and make sure it's, we understand what is transpiring here and what's correct and what's not.
Okay.
I'll see if that's possible.
Thank you.
Okay. So the hearing is open. But do we have any other business that we need to talk about tonight besides this?
Not much, but so just to be clear, we're done with this item for tonight. The
Yes.
motion did carry 6-1, and we will see the applicant back here on February 23rd at 6:30.
Yes.
Thanks.
Thank you.
Okay, do we have anything else? Schedule review. So now the schedule's blown up. So whatever I was going to tell you is now different, but no, it's fine. So we were intending to cancel the meeting on February 9th. We will still cancel the meeting on February 9th. We will be back here on February 23rd for this continued item. We have 2 study sessions that we need to schedule. One, which we had been looking at February 23rd, but so we'll go back to the drawing board and find an alternative date or dates for those. That's going to be the ZDO diagnostic report that you've heard some things about in the past is sort of rapidly coming to the end of its first phase, meaning we're going to have a report in the somewhat near future. And so the intent is for the report won't be final by end of February, but we had been thinking to come and just sort of give you an update on where that is kind of landing, and then sort of what next steps we might be thinking about, which is to start amending the code actually in response to some of the things that the consultants have recommended. So that's going to be coming. And then we are hard at work on the minor and time sensitive amendments packages for fiscal year 2026, which number of you have experienced in the past. We do try to do these amendment packages every 1 to 2 years with kind of things that have sort of risen to the top as having some level of urgency or issues where we're trying to comply with state law or housekeeping type amendments to the code, that kind of thing. And so we do have a list of items that we are working on. The board has green lighted those in concept to get started, not specific language. We'll be going back to the board May 10th, 17th, 10th, I think. I can't remember which is which. Anyway, mid-March, going back to the board
March
with
10th.
some drafts. And we would like to come talk to you about the concepts before we return back to the board. So I don't know if that's going to fit now given this, but we're going to see what we can do. So, and you will eventually be having a public hearing, which is tentatively scheduled for May 11th for the minor amendments public hearing. So that is what's
Okay.
going on. Martha.
The board policy session is March 10th for
Okay.
the minor time sensitive amendments and March 17th for the diagnostic report.
Okay.
I guess my opinion would be, I think it's fine to push the diagnostic report out after the board since it's not really
Right.
a decision that needs to be made.
Right.
So I don't know if we can do this hearing and a work session on the same night on the 23rd.
I think that's
But
potentially,
we'll
that
think
may be
about it.
possible. You probably all have to commit to a 3-hour meeting, which used to be the norm. So that's not out of the
Good old
realm of
days.
possibility. So we'll see. We might try to do both.
Okay.
All righty. That's
Okay.
all I have on schedule.
Well, sounds like we have a fair number of things coming up. So,
We do. And then other business, just to let you know, so we've got terms expiring again on the Planning Commission. Darcy's going to be reaching out to Commissioner Murphy and Commissioner Lopes to see if you are interested in re-upping. for
Should be
another
in your
term.
inboxes right now.
So you do not have to declare your intentions tonight on the screen, but please do respond to Darcy because I think there's some new protocols. We may not have to do a full recruitment type of thing if incumbents are reapplying. So we're going to look into that a little bit. So do let her know what you're thinking.
Yep, I sent
can
each
start.
of you an email tonight. So
okay.
Commissioners Murphy and Lopes.
So question about the next meeting, about that meeting.
Mhm.
Now, 3 hours long that night, because I have a 3-hour meeting prior to it. So
I mean, potentially we might want to do 2 items of business. So according to the bylaws, your meetings can go as late as 10. We don't go any later than that unless you all want to for some particular reason. I don't really think that the continuation of the one you just had should take a ton of time. Like there should be some written information ahead of time. We're not going to do a full staff report again. It'll just be sort of any additional information that Martha wants to share based upon the submittal that came in today and based upon whatever they presumably submit in the next 2 to 3 weeks. You can certainly set testimony time limit. I don't think we need to have 30 minutes from the applicant or an hour or, it should be able to be more efficient. We don't have to have Tom read the entire script again. Like it'll be more efficient than tonight was. So
Okay.
I think it's conceivable. And the other thing is if it goes long, we can push the study session off. But I think it would be good for us to have it queued up just because I think it's going to be the opportunity for you to see it before it goes to the board. And then I can share your feedback with them when we go talk to them about this minor amendment stuff, which I think is helpful. But if it doesn't work out, we can push it to March and it'll be fine. So.
okay.
Okay. One thing I will note is that we really it would be good if at least 5 of the people were here tonight could be here in 4 weeks. So just because you've heard it all and we're going to need to have a quorum to act that night too. So please do let Darcy know if you don't anticipate being able to be there because we could ask Tammy or Scott to review the tape and all of that too, if necessary.
I would recommend that they do that.
Yeah.
So they have some context, kind of what's behind all this, and they have the opportunity to hear the applicant's testimony because we really don't need to go through that again. In my opinion, I think we just need some clarification of some of the points of contention here, and then we can we can deliberate. That's what I'm hoping as well. So, yeah, that's a long speech I have to go through.
Yeah, it is. No, we won't do all that again.
Anyway,
We'll give you the abbreviated script.
abbreviation version. Okay. Okay, we're back. Let's get started.
Edit the script.
Yeah, let's go. How's that? Okay. All right. Anyone else have any other thoughts or comments for the good of the order, or are we done for the evening?
Tom, we don't want to make sure we look like we're skewing this thing to one side or the other. So if we don't have folks come in that are in opposition, it may look like we're looking at only one direction. And that's my major concern here, is that we don't want to look like that, hey, we've already made up our mind and we're not considering anybody else's opinions. And, you know, I know that that's difficult to do.
Yeah, I guess I wasn't seeing it that way. I was just seeing that we've already heard their testimony, all of us. They will be present, and what we will have is additional information, but on both sides, for us to consider in our deliberations. So I don't see it. I don't see how it would come across that way. But your point is well taken. I would want to do my best to make sure it doesn't feel like that. That's for sure.
I know you're very good at what you do, and you're very neutral in whatever you do, and I really appreciate that. And that's why I nominated you for that position to be the chair, because you look at both sides, and I just want to make sure that we don't ever get skewed in saying, "Hey, look, we're only looking out for one person."
Yeah, I agree. Yeah, you're preaching to the choir. So, okay, Martha.
Can I just jump in? Oh, I just wanted to let you know, Commissioner Wilson, that we certainly can't compel anyone who's submitted testimony in opposition to come and testify in person or submit additional written information. But I can tell you that they are following this, and they will have every opportunity to, and there will be an opportunity for testimony at the next hearing because we've left the record open. And in fact, there is somebody from DLCD listening to this, and so it's out there. There will be opportunities.
Great. Should be an interesting conversation. It would have been a difficult one tonight, I think. So I'm thinking the additional time will be helpful for us all. So, okay. All right, everyone. Well, thanks for hanging in there, and we'll see you all again in a couple of weeks.
4 weeks. 4 weeks.
Okay.
4 weeks.
Couple for,
23rd. All right.
All right. See you then.
Thanks, everyone. Good night.
Good night.
Good night, everyone.